Good. रिकॉर्ड भी होगा, ये भी होगा साथ में, लाइव लेगा, ठीक है, राइट. Good afternoon, students. Once again, welcome back to Plutus IAS. Right. So again, I welcome you to the special session. I would say series of lectures in which we are going to discuss the previous 10 years questions that have been asked from the asked in the previous prelims examination. Right. So we are going to discuss these previous 10 years questions subject-wise. So that will be more useful for you. So with this, not only you will be getting the idea of the questions and what are the right answers for the previously asked questions, but there are several other benefits also. Just before starting this session, let me just briefly elaborate you what are the other benefits you are going to get this from this program. So first thing is, you will also get to know the trend of the questions, which I mean from which subject you are going to get how many questions. So from various subjects, what are the weightage that is given to various subjects in the prelims examination and how it is being changed over the years. So you will come to a fair idea about this one also. So with this, what happens, you can focus on areas where major number of the questions, or we can say from a particular subject, many number of the questions are being asked. So you can focus your energy there, so that you will be benefited in that. So next thing is, you will also getting the trend. I mean, within the same subject, these special topics, particular topics, from where the questions are being asked repeatedly. So let's say, for example, center-state relations, or for that matter, governor, president. So in special areas, fundamental rights, fundamental duties, constitutional bodies, so you will get a fair idea that from where the questions are being actually asked. So what happens, what is the benefit of this one? You can focus, or whenever the prelims has already come very much closer, so you can specially focus on these areas. So in this way, the cost benefit will be more. So you can channelize your energy and the time into these specific areas from where the questions are being repeatedly asked. This is second benefit. And third one is, we will also see how many the analytical questions are being asked, how many factual based questions are being asked. So with this also, you will come to a fair idea that how many analytical type of questions are being asked, how many facts based questions are being asked. So whether, which questions you will be in a better position to eliminate few of the options, some of the options among the four, and you can come to a conclusion about the answer, or the questions, whether you are able to do that in factual questions or analytical questions. So along with the discussion, you can also make self-assessment about what is your guesswork. I mean, whether your guesswork is working or not. So though, let me remind you that in the just concluded exam, 2023 latest concluded exam, in that the scope for elimination has been removed for a large extent because of the type of questions that are being asked. However, still there is a fair chance. It's not compulsory that UPSC is going to continue that format of questions in the next coming years also, because the cutoff marks have been drastically reduced this year. It suddenly fell from 85 to around 75. So there is a drastic reduction in the cutoff marks, if you see. So there may be a chance that UPSC may not continue with the format. So previously, there was a case that if you apply educational guess, and if you are able to eliminate the answers, you could arrive at the correct answers. So if you analyze yourself whether that question is an analytical question or factual question, and if you are applying the guesswork or educational guesswork, and you are eliminating few options and coming to a conclusion, so where you are strong in that aspect, whether it is in analytical questions or factual questions. You can also make that analysis. So based on where the success rate is more, you can do the guesswork. Let's say you have attempted almost 75 to 80 questions. Let's say you have attempted 75 to 80 questions. Further, you want to solve 5 to 10 questions more, because you want to take the number of questions applied to and to 90. So if this is the case, so for 5 to 10 questions, those 5 to 10 questions, you can apply educational guess. So there you will be benefited with this kind of analysis. So this point also, I think you will be very well, you will be knowing very well that the damn sure questions that yes, this is the answer. So those kind of questions hardly be 30 to 35. So in rare cases, it might go to 40, 45. But in most of the cases, the damn sure questions that yes, I am sure with this answer. This is the answer for this question. For most of the students, I am not, talking about the students who are scoring marks like 125, 130, above 120 for that matter. So for them, the number can be different. But I am speaking about the majority students. So the students who will be knowing the damn sure answers for questions, the questions might be between 35 to 40 or 30 to 35. The rest of the questions, for the rest of the questions, they have to do guesswork. There is no other alternative. So in such cases, you have to just blindly, should not do blindly. Whatever the guesswork you are doing, it should not be blind. Whatever you are making, it should be educational guess, right? So for that, doing that also, you should have minimum information or knowledge about that issue. Then only then you will be in a position to do the guesswork also. So here, along with the questions and answers, you also try to know whether that question is a factual question or analytical questions, and where your guesswork is properly working. And based on that, in the actual examination, try to attempt those type of questions more. I mean, in which subject? Let's say geography. In that, if you are guessing the factual questions, you are guessing properly for fact-based questions. So in the examination, try to guess for the geography questions, that too fact-based questions. Let's say if you take the subject of polity, now which we are going to discuss. So for in polity, whatever the questions you are guessing, the analytical type of questions, if they are giving more success rate in the actual examination, try to go for the analytical questions and do not go for the factual questions. Right. So before going into the discussion, these are the few points I wanted to make you. I wanted to make clear to you. So keep these things in mind while we are discussing. Right. So while discussing the questions, we will go from latest to oldest. That is, we'll start with the 2023 questions, and we will try to discuss till 2014. So my idea is that it will take, we cannot complete all the questions in one session. So I'll try to take 2 or 3 sessions, and I will try to complete all the questions. So I have seen the questions. There are almost 152 questions in the polity subject in the entire 10 years. So it might take us for 2 to 3 sessions to complete, right? Right. So with this brief introduction, we will go into the questions, and we will see the questions. Right. First question is, keep reading the question also. Right. So first question is, in essence, what does the due process of law mean? So this is the first question. The question is about due process of law. So remember, there is another concept also along with the due process of law. There is procedure established by law. Procedure established by law. So there are many other things associated with that. So one comes from the British tradition or English tradition. The other comes from the American tradition. So so try to know all the things and the differences between what is meant by due process of law and what is meant by procedure established by law. So first of all, there was a concept of procedure established by law in India, and the judiciary invented the other one. So these kind of developments are there about these two things. So try to know other things about these two concepts also. So when you discuss the fundamental rights, FR, so these concepts are very, very important, right? So the options given are option A, the principle of natural justice, right? Option B is the procedure established by law. So opposite, I mean, other doctrine is saying, so this option B is not at all correct. So there is another doctrine apart from due process of law. So the option B, you can straight away eliminate. This is not at all correct. Option C is fair application of law. Option D is equality before law. So equality before law is also another concept. It is mentioned under Article 14 of the Constitution, right? So equality before law, and another related to this one, other concept is there, equal application of law, or we can say equality before law and equal protection by law. Equal protection by laws. So you can also eliminate this one. This is also not exactly related to due process of law. It is not exactly related to due process of law, right? So somewhat option A, what is mentioned is natural principle of natural justice. That is somewhat related to remotely related to the due process of law only. So we can say the due process can be a part and parcel of the principle of natural justice. So principle of natural justice is a very, very broad concept, that what is actually meant by principle of natural justice is, so by means of human being, by means of by birth itself, because of a person is a human being, he has certain rights, right? And there are some principles that are there in the nature, that right against discrimination, right to get proper opportunities, right not to be abused, etc. So there are certain principles, right? Principles of natural justice. Other principles, when we discuss about the administration, are, so a person cannot be his own judge, or a person cannot be judge of his own case. So this is one principle of natural justice, right? Other principle can be like a person cannot serve the two masters, etc. So these are all the principles that are known as principles of natural justice. So exact or in essence, what is actually meant by the due process of law is, it is the right. So it is what is exactly meant by the due process of law is, it is the fair application of law. So application shall be fairly applied to each and every person, right? So this is the actual meaning of the due process of law. So correct option is option C. It is the fair application of laws, right? So here in the principle of natural justice, some of the issues I have mentioned are also, they are also come under the human rights. So human rights are nothing but the rights which are which we are getting because we are because we have born as human beings. So similar category of rights, they are also the rights of natural justice. So the later part, what I mentioned, like a person cannot be judge of his own case, etc. These generally come under principles of natural justice, right? So this is about the first question, right? Next question is, this is the trend I was saying. So in the 2023 examination, a new kind of pattern of questions has been introduced. So this is one of those patterns, right? The question, let's see the question. Question is, consider the following statements. Statement 1 is, in India, prisons are managed by state governments with their own rules and regulations for the day-to-day administration of prisons. So this is statement 1. Statement 2 is, in India, prisons are governed by the Prisons Act of 1894, which expressly kept the subject of prisons in the control of the provincial government. The question is, which of the following is correct with respect to the above statements? So here we can see the statement 1 is a correct statement, because the states have their own rules and regulations and administrative rules when it comes to management of prisons. They are doing so because there is an act, that is the Prisons Act of 1894, which expressly kept the subject of prisons in the control of the provincial governments. Provincial governments, when the rule of the British is there, and when once independence is occurred, the provinces are now known as states. So the statement 1 is also correct, and the statement 2 is also correct, and the statement 2 is the correct explanation of the statement 1. So correct option is A. Both the statement 1 and 2 are correct, and the statement 2 is the correct explanation of statement 1. Right. Next, third question. Right, the question is, which of the following statements best reflects the chief purpose of the constitution of the country? So remember, carefully study the question. You have to catch the words like this, chief purpose, right? So try to catch these kind of keywords, right? Options are, first option is, it determines the objective for making of necessary laws, right? Next option, option B is, it enables the creation of political offices and a government. Yes, option B is correct, and option A is also seems somewhat correct, right? So it is also probably somewhat seems correct. It is also somewhat seems correct. Option C is, it defines and limits the powers of the government. Yes, this is, I mean, conceptual. When the debates were going about the constitution, preparation of a constitution or constitutional monarchy, when democracy was not popular, there was a concept called constitutional monarchy, right? So this is definitely correct. Fourth option D is, it secures social justice, social equality and social security. Yes, some objects like social justice, social equality and social security are, if we see worldwide, different constitutions are mentioned or have mentioned these, I mean, we can say these are ambitions, aims and ambitions that given to the, we can say, policy makers or upcoming the leaders who are going to head to the government. So these are certain ambitions that are given by different constitutions in different way, right? So if you see broadly, if you see, all of these things are there in the constitution, Indian constitution also, right? But if you see the chief purpose, the main purpose, if you see, it defines the limits and the power of the government. This, because of this essential reason, the constitution, the purpose, or we can say the concept of constitution has come. It has delineated the boundaries in which the government can act, and it also prescribed limits which it cannot be, I mean, those limits which cannot be crossed by the governments. It is, in a way, we can say constitution is the limit imposed on the government. We can say like that, right? Against the limit imposed on the government against the violations of the rights of the people. So this is the actual theoretical concept behind the concept of constitution. So what is the correct answer? Correct option is option C. It defines the limits and the powers of the government, right? Right. So here you remember, this is a purely analytical question, thought-based question. It is not based on facts. So you should not only be in a position to answer the factual questions, but you should be in a position to understand the conceptual aspects of the various subjects also, right? So this is a concept-oriented question, right? Next question, question number 4, that is, in India, which one of the following constitutional amendments were widely believed to be enacted to overcome the judicial interpretations of fundamental rights? So various options given are option A, First Amendment, option B, 42nd Amendment, option C, 44th Amendment, option D is 86th Amendment, right? So here you can see, you can clearly eliminate the 42nd and 44th constitutional amendment, because so whatever the difficulties were there for interpreting the fundamental rights even if you see the Indira Gandhi era, so there was during the Mrs. Gandhi era, when Mrs. Gandhi was the Prime Minister, there was a tussle between the judiciary and the government. So the judiciary, the government was trying to implement the DPSP, Directive Principles of State Policy. On the other side, the courts, they were trying to protect the fundamental rights. So there was a tussle between the government, or for that matter, to clearly say, there is a tussle between the executive and the judiciary. So the executive was trying to implement the DPSP, Directive Principles of State Policy, and on the other side, the courts or the judiciary was trying to protect the fundamental rights of the people. So whenever the executive was trying to implement the DPSP, and in that matter, it was taking help of the parliament to amend the fundamental rights, because some fundamental rights were coming in the way for implementing the DPSP. So some people went to court that their rights have been violated. So the court was giving judgments in favor of the fundamental rights. So at that time, you will also see the narrow interpretation of the fundamental rights. But the story has happened between 25, 26, 24, till 32, 33. So these constitutional, till these constitutional amendments only, the story has ended. So in the whatever happened in the 42nd and 44th constitutional amendments is different. So by this time, 42nd Amendment Act, so the emergency has been imposed in the country. So till that, whatever it is felt by government of Mrs. Gandhi, which were obstructing the authority of the executive, so all these measures have been changed. That the election, many things are in that. Many things are there in that. That once a bill is passed by the parliament, the president should not send it back even for reconsideration, etc. So these kind of changes were there in the 42nd Amendment. You know very well about them. And the 44th Amendment Act is, so whatever the changes that have been brought in the through the 42nd Amendment Act, that have been corrected by the 44th Constitutional Amendment Act. So, easily these two options can be eliminated. Next, option D is 86th Amendment. So this also you should be knowing. So 86th Constitutional Amendment, majorly pertaining to Right to Education Act. So through this 86th Amendment Act, it has been made a fundamental right. So which remains last? Option A remains, First Amendment Act. So I will tell the scenario, background of the First Amendment Act. So immediately after the independence, the Nehru government was trying to bring in the land reforms. So land reforms, you know very well. There are three aspects in that land reforms. First, first step taken as part of the land reforms by the government is elimination of intermediaries. Elimination of intermediaries. So jamindaris, you know, jamindars. So till centuries back, they were just sucking the blood of the farmers. They were exploiting. Jamindars were exploiting the farmers. So first focus of the newly formed government was to eliminate these middlemen. Elimination of the middlemen, that is elimination of jamindaris. For that matter, the government has brought in the abolition of Jamindari Act. But what happened? Many jamindars, they went to approach the court saying that our fundamental right to property has been taken away by the government. So because what happened with the abolition of Jamindari Act, Jamindar, the position of jamindars and other various middlemen, they have been declared illegal, and the land has been taken by them. It is, the government tried to distribute the land among the poor. So the landlords, they went to court saying that our right to property has been violated, our fundamental right to property has been violated. So the court said that, so whatever you are doing, it said to the government that whatever you are doing is wrong, because you cannot violate the fundamental right of the people. So to overcome that, first constitutional amendment has been brought in. So with this, the different schedule, a new schedule has been created, that is 9th schedule. Till then only 8 schedules were there. 9th schedule has been created, and all the laws related to land reforms. All the laws related to land reforms have been kept in the 9th schedule, and it has been said that, and there is a constitutional amendment has been made that, so whatever the items mentioned in the 9th schedule, they are out of judicial review. Out of judicial review. So the court cannot touch those laws, saying that, and whatever may be the cause, the court cannot touch the items that are mentioned in the 9th schedule. So all the laws related to land reforms have been kept in the 9th schedule. However, after that, there are many things happened with the 9th schedule. Apart from land revenue acts, land reform acts, many other things have been put on in the 9th schedule, including the reservation of excessive reservation of above 50% reservation of Tamil Nadu, that is given in Tamil Nadu state. So all those laws are there. Now almost 300 laws are there in the 9th schedule. So at some point of time, Supreme Court has said that it will also it has the power to also review the laws or acts mentioned in the 9th schedule. It has said that, but till now it has not actually gone and reviewed the laws that are mentioned in the 9th schedule. We will see in the future. It may or may not happen, but the Supreme Court has said after some time that it can, if it wants, can review the acts or laws or items, whatever it may be, that are mentioned in the 9th schedule. It can review them also. So the correct option is option A, First Amendment. Right. Next question, question number 5. Right. So the question is, consider the following organization and bodies in India. Right. So first option is the National Commission for Backward Classes, the National Human Rights Commission, the National Law Commission, the Consumer Disputes Redressal Commission. How many of the above are constitutional bodies? So you can see clearly it is a completely facts-based question. So it is only National Commission for Backward Classes. It is only the constitutional body. Remaining are all the legal bodies. I mean, they are established by a law, not by the constitution. Right. So correct option is option A, only one body is constitutional body. So I was mentioning about the change of pattern in the 2023 examination. First pattern of questions we have seen, that is statement 1 and statement 2 are given, and there are 4 different types about options about those. That is the first change, and the second one is this kind of pattern. So a series of options will be given, 1, 2, 3, 4, and the question will be like this: how many of the above are correct, or how many above are incorrect, etc. These are the questions. So options are like this: only 1, only 2, only 3, only 4. So here you will get confused a lot, and practically the option of eliminating the answers has been taken away from these type of questions also. Right. So beware of these 2 type of questions, pattern of questions that have been introduced in the 2023 examination. It is very difficult to eliminate options in these type of questions. Right. So in those, this is the second type of question, second pattern of questions. Right. Next is question 6. So it is also in the same pattern. The question is consider the following statements. Statement 1 is, if election of the President of India is declared void by Supreme Court of India, all acts done by him or her in the performance of duties of his or her office of President before the date of decision become invalid. So clearly this is incorrect statement. There is a judgment of the Supreme Court that if for any reason, including the election of, because of any reason, whatever may be the reason, if election of President has been cancelled, so whatever the decisions, official decisions taken by him or her till that date of disqualification, they will not be void. They will be in force. This was the judgment of the Supreme Court. So they shall not become invalid. They will be in force. So this is an incorrect statement. Next statement is, elections for the post of President of India can be postponed on the ground that some legislative assemblies have been dissolved and elections are yet to take place. So this is also incorrect statement, because this matter has also been taken to the Supreme Court that some state governments went to court that our our legislative assemblies are they are not in positions, elections have to take place, so until then please postpone the election of the president. The Honorable Supreme Court said nothing doing, whether a particular state assembly is there or not, that doesn't matter, the elections have to go forward. So this statement is also incorrect. Next is, when a bill is presented to the President of India, the Constitution prescribes time limits within which he or she has to declare his or her assent. So clearly this is also an incorrect statement. So if you see the entire Constitution, also there is nowhere the time limit for President is mentioned, that within this time the President has to give his assent. So because of this reason that time limit is not mentioned, a particular type of veto power comes to the President indirectly to the President of India, that is pocket veto. So when you study about the President, especially his rights with respect to Parliament, etc., his rights during the legislative process, you will also study about this. So correct option is, question is, how many of the above statements are correct? Right. Option is D. None of the above statements are correct. Right. Next question, with reference to finance bill and money bills in the Indian Parliament, consider the following statements. Statement 1 is, when the Lok Sabha transmits finance bill to the Rajya Sabha, it can amend or reject the bill. Yes, this is a correct statement. Be clear before going into the discussion. Just I want to make some things clear, that be sure about whether it is mentioned money bill or finance bill. So we many times we get confused between money bill, and we interpolate aspects related to money bill to the finance bill, and aspects related to finance bill to the money bill. So don't do that. Be clear what are the provisions related to money bill and what are the aspects related to finance bill. So the first statement is an incorrect statement, because what is actually meant by finance bill is it will have few items related to money bills that are actually mentioned in Article 110 of the Constitution. The items, if all the items that are there in a particular bill, they all pertaining to Article 10 or items mentioned in the Article 10, then that bill particularly specially become the money bill. So apart from any of the items are mentioned that are there in the Article 110, apart from that there are some other items are also there in that particular bill. Best example is the Aadhaar bill. Right. Aadhaar bill, there are some aspects or some items that are there in the Article 110, like drawing the money from the Consolidated Fund of India, etc. And apart from that, there are many other things that related to Aadhaar, how a person should be enrolled in the Aadhaar, how data has to be maintained. So which organizations can take the data of the Aadhaar, which organizations cannot take the data, what are the rights of a person, etc. There are n number of things. So the government classified, or speaker for that matter has classified it as a finance bill, and some people went to court that how it can become a money bill. So however, the court has accepted that yes, that is a money bill, there is no problem in that. So what I'm trying to tell here is few items that are they mentioned in the Article 110, that is majorly drawing money from the Consolidated Fund of India, something related to Consolidated Fund of India, that is there. Apart from that, many other things are there. Then that is known as finance bill. If exclusively the items mentioned that items mentioned in Article 110, only those things are there, then that bill will become the money bill. Right. So if you see the statements, so because apart from the items mentioned in the Article 110, there are other things also there in the finance bill. So for that matter, the Rajya Sabha either can amend the bill or can reject the bill, right? Because apart from the items that are there in the Article 110, many other things are also mentioned in that, right? Next statement is, when Lok Sabha transmits money bill to the Rajya Sabha, so here see, money bill is mentioned. In the first statement, finance bill is mentioned, right? So when Lok Sabha transmits money bill to Rajya Sabha, it cannot amend or reject the bill. It can only make recommendations. Yes, this statement is a correct statement, because when it comes to money bill, the Rajya Sabha has very few powers, right? Next is option 3, number 3. In case of disagreement between Lok Sabha and Rajya Sabha, there is no joint sitting for money bill, but a joint sitting becomes necessary for the finance bill. Yes, if in matters of money bill, there is no question of joint sitting. So because in the finance bill, there apart from the items that are there in the Article 110, there are other items are also there. So then joint sitting is possible, right? So how many of the above statements are correct? All the 3 statements are correct. So remember that one thing is, for the 2023 examination, the official key is not yet come. Official key, I mean the UPSC is from some time on releasing the answers for the official answers for the examination held. Till until now they have not come, and some other experts have given that in this only statement 1 is correct, that is this first statement is correct, or sorry, the second statement is correct, and statement 1 and statement 3 are incorrect. So like that they have interpreted, but we can also wait and see till the official key is released. But however, until now majority of the opinion is this one only, right? So correct option is option C, right? Next question number 8. That is, question is, with reference to scheduled areas in India, consider the following statements, right? So statement 1, within a state, the notification of an area as a scheduled area takes place through the order of the President. Second statement, with reference to scheduled areas in India, sorry, there is a problem with the question. Okay. Second statement is, the largest administrative unit forming the scheduled area is the district, and the lowest is the cluster of villages in a block. Next is, the chief ministers of the concerned states are required to submit annual reports to the Union Home Ministry on the administration of the scheduled areas in the states. So clearly you can see statement 3 is an incorrect statement. This power is not at all there with the chief minister. Either it can be given to the governors of the state. Sometimes the president can appoint a special officer to know about the conditions of the scheduled tribes and the scheduled castes, issues related to scheduled areas also. The president wants, he can appoint a commission. So mostly this power is given to certain governors of certain states. So this statement is incorrect. First statement is correct, because whenever it comes to scheduled areas, the president has the wider powers. He has the powers to declare an area as a scheduled area. So this power of president is mentioned in the constitution itself. Second is, so second statement is also correct. Administrative unit, largely it can be a district, and smallest it can be a cluster of few villages. So this statement is also correct. So correct option is option B. Only 2 statements are correct. Right. Next question, consider the following statement. Statement 1. Right. So consider the following statement. Statement 1 is, the Supreme Court of India has held in some judgments that the reservation policies made under Article 16(4) of the Constitution of India would be limited by Article 335. 335 for maintenance of efficiency of administration. Statement 2 is, Article 335 of the Constitution of India defines the term efficiency of administration. So clearly you can see this term is never defined in the Constitution, right? So statement 1 is correct. So to maintain efficiency in administration, the reservation, there can be certain limitations in the reservation. So for that matter, for many time there was reservation in the job, entry into the jobs, but that reservation is not applied when it comes to promotions. but after many judgment, I mean many cases went to the Supreme Court that reservation shall also be applied in the promotion also. That stand has now been accepted by the Supreme Court. Now reservation is applicable in promotions also. Apart from that, there are certain areas like recruitments in the dentist. So there, in some areas, reservation won't apply, like in the space missions, in the space explorations, etc. So it is in certain areas, the reservation won't apply because to maintain efficiency in the administration. So correct option is statement 1 is correct, but statement 2 is incorrect. Right. Right. Clear? I think this question is clear. Next we will go to another question. So another question is question number 10. With reference to home guards, consider the following statements. Right. So these kind of questions are coming. I mean, it is not this question is mostly rather than polity, is mostly related to current affairs. So I'm skipping this question. Right. So this question is also fairly fact-based question. So with reference to India, consider the following pairs. So action, the act under which it is covered. So first is unauthorized wearing of police or military uniforms. It is Official Secrets Act of 1923. Next is knowingly misleading of otherwise interfering with a police officer or military officer when engaged in their duties, that is mentioned in the Indian Evidence Act of 1872. Next is celebratory gunfire which can endanger the personal safety of others, that is Arms Amendment Act of 2019. So question is, how many of the above pairs are correctly matched? So you can see these first two pairs are correctly matched. This is an incorrect match, right? So only 2 are correctly matched, that is first and second questions are correctly matched. Right. Question number 12. Question number 12. The question is, consider the following statements in respect of national flag of India according to the flag code of India. So this is also completely fact-based question, facts-based question. However, I am going through the question. Statement 1. Statement 1. One of the standard sizes of national flag of India is 600 mm into 400 mm. The ratio of the length to the height or width of the flag shall be 3:2. So this is a fact-based question. Clearly you can see this is incorrect and the second statement is correct. So correct option is option D. Statement 1 is incorrect, but statement 2 is correct. So this is also a fact-based question. So you cannot do much unless you have the correct information about the flag code of India. Right. Next question. Question number 13. Right. So sorry. Question number 13 here is consider the following statements with respect to Constitution Day. So you can also see this is also a fact-based question. So consider the following statements in respect of Constitutional Day. Right. Statement 1. The Constitution Day is celebrated on 26th November every year to promote constitutional values among the voters. So this is the first statement. Yes, on the face of it, this statement looks correct and it is correct statement also. The Constitution Day is celebrated on 26th November every day to promote constitutional values among citizens. Statement 2 is on 26th November 1949, Constitutional Assembly, Constituent Assembly of India set up a drafting committee under the chairmanship of Dr. B.R. Ambedkar to prepare a draft Constitution of India. So clearly it is incorrect statement. So we can say this is a fairly easy question. So on this day, the Constitution actually has been adopted, right? The Constitution has been adopted by the Constituent Assembly. However, 26th January 1950, the Constitution has officially come into the force. So correct option is, it is relatively easy question. Statement 1 is correct, but statement 2 is incorrect. Right. Next question. Consider the following statements in relation to Janani Suraksha Yojana. So this question either you can cover in the government policies also, the policies and schemes of the government. However, you can also include this in the governance part of the polity also. However, I am taking this question here. The question is, consider the following statements in the context of interventions being undertaken under, sorry, this is the next question, sorry. The question, 14th question, sorry. Consider the following statements in relation to Janani Suraksha Yojana. Right, statement 1 is, it is a safe method, safe motherhood intervention of the state health departments. Right. Second statement, its objective is to reduce maternal and neonatal mortality among the poor pregnant women. So clearly you can say that this is a correct statement. The objective of the program is to reduce maternal and neonatal mortality among the poor pregnant women. Third statement is, it aims to promote institutional delivery among poor pregnant women. Yes, this statement is also clearly correct. One of the major objectives of the program is to increase the institutional delivery, especially among the poor pregnant women. Right. So its objective includes providing public health facilities to sick infants up to 1 year of age. Right. So this statement is also correct. So its objective includes providing public health facilities to sick infants up to 1 year of age. So it is a first option, it is a safe motherhood intervention of state health departments. So it is actually a scheme brought in by the central government, not actually the initiative of the state health departments. So only 3 options are correct, 2, 3 and 4. Right. So this is about the question. Right. Next question is, consider the following statements in the context of interventions being undertaken under the Anemia Mukt Bharat strategy. So this also you can either consider in current affairs, because it is initiative, this initiative has recently taken. Apart from that, you can consider this one in governance also. Right. So right. So the question is, it provides prophylactic calcium supplementation for the preschool children, adolescents and pregnant women. Next statement is, it runs a campaign for delayed cord clamping at the time of childbirth. Third statement, it provides for periodic deworming to children and adolescents. Next one is, it addresses non-nutritional causes of anemia in endemic pockets with a special focus on malaria, hemoglobinopathies and fluorosis. So you can see it provides prophylactic calcium supplementation for preschool children, adolescents and pregnant women. So you can see clearly this is not parts and parcel of this program. These things are covered in another program. There is another program. So these things are kind of, they are there in the another program. Right. Next, 3 statements. It runs a campaign for delayed cord clamping at the time of child of birth. It provides for periodic deworming to children and adolescents. And the 4th statement, it addresses other issues that are related to anemia. So this is also there. So statement 2, 3 and 4 are correct. So among them, 3 statements are correct. Right. So this is about the another government program question. Right. Right. So next question, question number 16th. The question is, consider the following statements. Statement 1 is, India's public sector healthcare system largely focuses on curative care with limited preventive promotive and rehabilitative care. So this is the first statement, sorry. So India's public healthcare system largely focuses on curative care with limited preventive, promotive and rehabilitative care, right. Second statement is, under India's decentralized approach to healthcare delivery, the states are primarily responsible for organizing health services, right. Right. So if you see broadly, before some time, the statement 1 looks correct, because at one point of time we were not that much giving importance to preventive health care. We were largely focusing on the curative health care. So, but let's say after the upcoming because of the National Health Mission and measures like Ayushman Bharat. So we cannot anymore say that India is not focusing on the preventive health care. So earlier, once upon a time, the focus was on curative care. Curative care means, there is a broad difference between preventive care and curative care. I will make it clear. Preventive care means taking health measures or safety measures before occurrence of a disease. These are known as preventive health care. This is known as preventive health care. Curative healthcare is once the disease occurs, then we are taking the treatment, etc. Anything that is known as curative healthcare. So before National Health Mission, Ayushman Bharat, other measures, other programs. So we can say we were there. We were like we were in the zone of curative healthcare. But after all these measures, we can say we are cautious, or we can say actively looking forward to the preventive health care. So first statement becomes incorrect. Statement 1 becomes incorrect after all the measures taken by the government. Statement 2 is, under India's decentralized approach to healthcare delivery, the states are primarily responsible for organizing health services. Yes, this is a correct statement, because if you see the 7th schedule, distribution of powers, there are 3 lists, central list, state list and concurrent list. The subject health, it is mentioned in the states list. So largely the funds will be provided by the central government. However, the actual implementation of the health programs, including the health camps, etc., everything, that is the primary responsibility of the state governments only. So statement 2 is correct, right. So don't be kind of that, don't be in a blind situation that, so India is not focusing on the preventing healthcare, it is only taking measures towards the curative healthcare. So that has gone, that period has gone. Now we are actively taking steps towards, or for that matter, have already taken steps regarding the preventive healthcare also, right. So another, same kind of question, how many of the above statements are correct? So because of the paucity of time, I'm leaving this question, a similar question, right. So this is interesting question. We can also include this in the current affairs also, because the question is about the 15th Finance Commission. So question is, consider the following. The options are demographic performance, forest and ecology, governance reforms, stable government, and tax and fiscal efforts. So completely it is also a fact-based question, facts-based question. Question is, for the horizontal tax devolution, the 15th Finance Commission used how many of the above as criteria other than population, area and income distance? So among them, the demographic performance, forest and ecology, and tax and physical efforts. So these 3 all have also been considered by the 15th Finance Commission. Government reforms and a stable government. So these are also actually, especially the 4th option, it rather, looks very, very superficial. So simply you can eliminate this option. Governance reforms, earlier there was emphasis about the grants to the states have been linked to the reforms that have to be taken in the when it comes to local bodies or local self-governments. Right. However, this is not part here. So these three, 1, 2, and 5, democratic performance, forest and ecology, tax and fiscal efforts. These three have been given in the fifth. These have been taken when deciding the weightage by the 15th Finance Commission. So correct option is only 3. Right. So in total, this is the last question in 2023. So in total, there are 19 questions from the polity and governance. So you can see, so roughly you can take this figure as 20. So out of 100 questions, you are getting 20 questions from the polity. So how much is the weightage? 1/5 of the weightage is given to the polity subject. So with this, you can understand the importance of polity subject when it comes to prelims examination. Apart from that, most of the questions are analytical based questions only, and hardly here and there are some questions, fact based questions, that too related to schemes, government related schemes, and few questions related to facts like national flag code, etc. So most of the questions are conceptual based. Once you have the idea and clear understanding of the concepts, you will be in a position to secure 16 to 17 marks from the polity subject. Right. So now we will go into the next year, 2022, and see the questions from the 2022 paper. Right. So first question in 2022 examination. Right. In India, which one of the following compiles information on industrial disputes, closures, retrenchments, and the layoffs in factories employing workers? So options are Central Statistics Office, Department for Promotion of Industry and Internal Trade, Labor Bureau, National Technical Information System, Manpower. So clearly, it is a fact-based question. Question is Labor Bureau. So this takes care of all the things like industrial disputes, closures, retrenchments, and layoffs in factories employing the worker. So simple, straightforward question. However, you should have the information to answer this question. Right. Next question, question number 2. Right. Question is, in India, what is the role of the Coal Controllers Organization, CCO? So it is a fact-based question. Right. So question is, COO is the major source of coal. Statistics in Government of India. Sorry, CCO is the major source of coal statistics in Government of India. Second statement is, it monitors progress of development of captive or coal or lignite blocks. Third option is, it hears any objection to the government's notification relating to acquisition of coal-bearing areas. Statement 4, it ensures that coal mining companies deliver the coal to end users in a prescribed time limit. So clearly, this statement 3 is incorrect statement. It is not the responsibility of CCO. However, the rest, first 3 options, these are all correct about the Coal Controllers Organization. So correct option is option A. Statements 1, 2, and 3 are correct. Right. Next question, third question. Question is, if a particular area is brought under the 5th schedule of the Constitution of India, which one of the following statement best reflects the consequence of that change? So statement 1 is, this would prevent the transfer of land of tribal people to non-tribal people. Option B, this would create a local self-governing body in that area. So clearly you can see this is an incorrect statement. Before that also, so throughout the country there are local self-governments, right? So whether it is a scheduled area or a non-scheduled area. So there is a provisions for local bodies everywhere. Through the 73rd and the 74th Constitutional Act, we have made this possible. And so earlier, the local bodies were not applicable to scheduled areas with the PISA Act, PESA. So, right. So, Panchayat Extension to Scheduled Areas Act. So, through this act, we have taken the local body institutions to scheduled areas also. So, option B becomes incorrect. Right. Next statement is this would convert that area into a union territory. So it is a blindly, it is incorrect statement. You can clearly eliminate this statement. This will not become a union territory. There is no provision like that. Option D, the state having such areas would be declared a special category state. So this statement is also incorrect. You can clearly eliminate that statement because there is no provision that the scheduled area states will become the special category states. So the criteria for declaring special category states is completely different criteria is there. And however, nowadays government has not at all ready to grant this special category status to any, it is not at all ready to further confer this status, special category status on any other state. So correct option is option A only. This would prevent the transfer of land of tribal people to non-tribal people. So this is to safeguard the local people and prevent the outsiders from entering that area and purchase land. And the belief of the government is that, so once the non-locals enter the scheduled area, if they acquire property there, they may exploit the local people there, because they will be, the local people, scheduled area people will be practicing primitive practices. They are innocent. So because of all these reasons, the acquiring of property, especially land property, has been prevented in the scheduled areas. Only a scheduled area person can purchase the land from another scheduled area person. Right. So this is about this question. So correct option is option A. Next question, question number 4. Consider the following statements. Statement 1 is the India Sanitation Coalition is a platform to promote sustainable sanitation and is funded by the Government of India and the World Health Organization. This is the first statement. Second statement is the National Institute for Urban Affairs is an apex body of the Ministry of Housing and Urban Affairs in the Government of India and provides innovative solutions to address the challenges of urban India. Right here, you can see the Sanitation Coalition is a platform to provide sustainable solution and is funded by the Government of India and the World Health Organization. So this statement is incorrect. Second statement, the National Institute of Urban Affairs is an apex body of the Ministry of Housing and Urban Affairs in Government of India and provides innovative solutions to address the challenge of urban India. So this statement is a correct statement. So correct option is option B, only statement 2 is correct. Right. So next question is question number 5. With reference to the Tea Board in India, consider the following statement. So either you can study this question in geography also when you discuss the plants, etc. But however, because it is there, organizations, etc., you will study in polity. So because of that reason, I have included this question here. Right. Question is, with reference to Tea Board of India, consider the following statements. Right. The statements are, right. The Tea Board is a statutory body. So this is the first statement. Second statement is, it is a regulatory body attached to Ministry of Agriculture and Farmers Welfare. Third question is, third point is, the Tea Board's head office is situated in Bengaluru. Fourth option is, the board has overseas offices at Dubai and Moscow. So here, statement 1 is correct. The Tea Board is a statutory body, or for that matter, any board established for any particular crop, or we can say whether it is a plantation crop, anything, Cotton Commission of India, etc. Other boards are also there. Tea Board is there, Coffee Board is there, Rubber Board is there. So many other boards are there. They all are statutory boards. Statement 2 is a incorrect statement. Statement 3 is also incorrect statement. Fourth option, the board has overseas offices at Dubai and Moscow. Yes, this is a correct statement because the tea is much more in demand in these places, and we further want to promote tea here. So statement is 4 is a correct statement. So correct option is option D. Statement 1 and 4 are correct. Right. Right. So next question, question number 6. Question is, consider the following statements. Statement 1 is, pursuant to the report of H.N. Sanyal Committee, the Contempt of Courts Act 1971 has passed. Statement 2, the Constitution of India empowers the Supreme Court and the High Courts to punish for contempt of themselves. This is the second statement. Third statement is, the Constitution of India defines civil contempt and criminal contempt. Fourth option, in India, the Parliament is vested with the powers to make laws on contempt of court. So clearly you can see here, this is actually one of the major problems also. I mean, some experts, constitutional experts say that this is a problem because there is no definition what constitutional, actually what is meant by civil contempt and criminal contempt. So the Constitution did not define it. So there are interpretations that civil contempt is whenever a person, we can say, refuses to oblige a judgment given by the court. That is considered as civil contempt. And criminal contempt is whenever a person tries to influence the, we can say, adjudication process of the court. If a person tries to interfere in that process, that is considered as criminal contempt. Right. Another concept is there in the criminal contempt itself, that is scandalizing the judiciary or scandalizing the judicial process. So that is also considered as criminal contempt. However, the Constitution did not define what is meant by criminal contempt and what is meant by civil contempt. Rest of the statements are correct. Rest of the 3 sentences, statements 1, 2 and 4, they are correct. So the correct option is option B. Statements 1, 2 and 4 are correct. Right. Next question. With reference to India, consider the following statements. So statement 1, government law officers and legal firms are considered as advocates, but corporate lawyers and patent attorneys are excluded from the recognition as advocates. Second statement, bar councils have the power to lay down the rules relating to legal education and the recognition of law colleges. Right. So which of the statements given is or are correct? So statement 1 is incorrect because the corporate lawyers and patent attorneys, they are also considered as advocates. There is no bar on their recognition. Right. So second statement, bar councils have the power to lay down rules relating to legal education and the recognition of law colleges. So bar council has the power to do such thing. So statement 2 is correct. So correct option is option B. Only statement 2 is correct. Right. Next question, question number 8. Right. This question is, consider the following statements. The statements are, statement 1 is, a bill amending the Constitution requires a prior recommendation of the President of India. Right. Next question, when a Constitution amendment bill is presented to the President of India, it is obligatory for the President of India to give his or her assent. right? That is the second question, statement. Third statement is a constitutional amendment bill must be passed by the Lok Sabha and Rajya Sabha by a special majority, and there is no provision for joint sitting. So here you can see statement 1 is incorrect statement. Bill amending the constitution requires prior recommendation of the President of India. So for constitutional amendment bill, there is no requirement of prior permission of the President. But however, when it comes to money bills and finance bills, there is requirement of President. Prior recommendation of the President is required. Second statement is correct. So whenever a constitutional amendment bill is passed by the President and presented to the President, he or she has to give assent, and they cannot, or he or she cannot resend it for reconsideration. Next is a constitutional amendment bill must be passed by both Lok Sabha and Rajya Sabha by a special majority, and there is no provision for joint sitting. Yes, this statement is also a correct statement. So the correct option is option B. Statements 2 and 3 are correct. Right. Next question, question number 9. Right. So question number 9, consider the following statements. Statement 1 is, the Constitution of India classifies the ministers into 4 ranks: visa, cabinet minister, minister of state with independent charge, minister of state, and a deputy minister. Next statement is, the total number of ministers in the union government, including the prime minister, shall not exceed 15% of total number of members of Lok Sabha. So question is, which of the statements given above is or are correct? So clearly this statement is incorrect. There is no classification of ministers in India, especially that is not mentioned in the Constitution. So we have made that that classification for the benefit of administration. It is not at all mentioned in the Constitution. So the only thing that is mentioned in the Constitution is, that is cabinet. The word cabinet is mentioned and prime minister is mentioned. So there is a mention of cabinet, not cabinet, I am really sorry, Council of Ministers. Council of Ministers. Right. So Council of Ministers, that is headed by the Prime Minister, that is there in the original Constitution. However, the word cabinet is also included, but it is included later with the amendment. So that particular amendment has made for this purpose only. So earlier there was no limit on the number of ministers that can be appointed. After that, it was leading to like problematic things, like many number of MPs, they have been appointed as ministers, especially in the state governments. Many number of MLAs and MLCs, they have been incorporated into the cabinet because of various political and other reasons. So it was leading to a lot of inefficiencies and problems. So because of that reason, a constitutional amendment has been brought in, wherein the total number of ministers in the cabinet, they shall not exceed 15% of the total number of members of Lok Sabha, including the Prime Minister. Right. So this is a correct statement. This has been made with an amendment to Constitution of India. Right. The correct option is option B. Only statement 2 is correct. Right. Next is question number 10. Question number 10. Which of the following is or are the exclusive powers of Lok Sabha? Right. So option 1, to ratify the declaration of emergency. So this is not the exclusive power of Lok Sabha. Here, when it comes to emergency, both Rajya Sabha and Lok Sabha are they have equal power, right? So for that matter, we can say the Rajya Sabha itself has somewhat better. It has better placed, because sometimes the Lok Sabha may be dissolved for various reasons. So at that time, only Rajya Sabha will be there, and the Rajya Sabha has to ratify that imposition of emergency. Right. Second statement, to pass motion of no confidence against the Council of Ministers, to pass motion of no confidence against the Council of Ministers. Yes, this is the exclusive power of Lok Sabha, and this power is not there for the Rajya Sabha. So you might be knowing the principle of collective responsibility. So the Council of Ministers that is headed by Prime Minister at the center, and sorry, that is headed by the Prime Minister. It is responsible for the, it is accountable for the Lok Sabha or lower house of the Parliament. So until the time it has the confidence of Lok Sabha, so that for that time only the Council of Ministers will remain in power. So once it loses the confidence of Lok Sabha, they have to resign. So to pass a motion of no confidence against Council of Ministers, it is the exclusive power of Lok Sabha. To impeach the President of India, this is also incorrect statement, because both the houses have equal power here also. So select the correct answer using the code given below. Right. So correct option is option B. Only statement 2 is correct. Next question, question number 11. Right. So question is, with reference to anti-defection law in India, consider the following statements. Right. The statements are: the law specifies that a nominated legislator cannot join any political party within 6 months of being appointed to the House. So it is a incorrect statement. There is a twist of facts here. Actually, a nominated member, if he wants, so he has to join any political party within the 6 months. So after 6 months, if he joins any political party, he will be disqualified under the anti-defection law. So this is an incorrect statement. Second statement, the law does not provide any time frame within which the presiding officer has to decide a defection case. So this is a correct statement, because there is no legally it is not decided that the chairman, or we can say the chairman of the house, or the presiding officer, whether it may be speaker or the speaker of the Lok Sabha, or chairman of the Rajya Sabha, or for that matter the speaker in the state legislative assemblies also. There is no time frame prescribed in the act, in the Anti-Defection Act, that the anti-defection petition has to be disposed. However, because of misuse of this provision in Nabim regime, in a particular case, the Supreme Court has ruled that in 6 months' time, the presiding officer should decide on the anti-defection cases or petitions that have come to the presiding officer. However, it is not actually being followed by various presiding officers. We are seeing many examples, especially in the state governments, in various state assemblies. So this particular rule has not at all been followed. So till now, officially there is no clear mention of time limit when it comes to presiding officers, whenever he or she is deciding on the anti-defection petitions. So correct option is option B. Only statement 2 is correct. Right. So next question, question number 12. Right. Consider the following statements. Statement 1 is: Attorney General of India and Solicitor General of India are the only officers of the government who are allowed to participate in the meetings of the Parliament of India. Right. Statement 1: Attorney General of India and Solicitor General of India are the only officers of the government who are allowed to participate in the meetings of the Parliament of India. Next is, according to the Constitution of India, Attorney General of India submits his resignation when government which appointed him resigns. So statement 2 is completely incorrect, because there is no mention of resignation of Attorney General of India that Attorney General should resign whenever the government which appointed him loses power or resigns. So there is no mention like that, but the tradition is that, so after the completion of the 5 years of the government, the Attorney General also, resigns along with the government, but this is followed as a tradition. It is not mentioned in the Constitution, and the Constitution do not says it. So Attorney General of India and Solicitor General of India are the only officers of the government who are allowed to participate in the meetings of the Parliament of India. So actually only Attorney General is allowed, Solicitor General is not allowed. There is no mention about the Solicitor General. Actually the position itself, the Attorney General is not mentioned in the Constitution. So Solicitor General is not mentioned in the Constitution. Only Attorney General is mentioned, and he or she has the power to attend the meetings of the Parliament, and he also attend the meetings of the committees, but he do not have the power to vote. So this is also incorrect statement. So which of the above statements given is or are correct? So neither statement 1 nor statement 2 are correct. Sorry, option D, neither 1 nor 2. Right. Next question, question number 13. Right. So question is, with reference to writs issued by courts of India, with reference to the writs issued by the courts in India, consider the following statements. Consider the following statements. Right. Statement 1 is, mandamus will not lie against a private organization unless it is entrusted with a public duty. Right. Mandamus will not lie against a private organization unless it is entrusted by a public duty. So you can see this is a correct statement. So it will not apply to a private organization unless it is entrusted with a public duty. Second statement, mandamus will not, you will know mandamus is one of the 5 writs that will be issued by the, that can be issued by the higher judiciary in India, that is Supreme Court and the High Courts. Second statement is, mandamus will not lie against a company even though it may not be a, it may be a government company. Right. So clearly you can say it applies to government company. It applies to a government company because that government company comes under the definition of public authority. So it applies to that particular company. Statement 3, any public-minded person can be a petitioner to move to the court to obtain the writ of quo warranto. So right, this statement is a correct statement. Any public-minded person can go to the court and file the quo warranto writ. Quo warranto means at what authority? Quo warranto means what authority? You should be knowing the meanings of the warrants also, sorry, writs also. At what authority? Mandamus means, right, we are ordering. We are ordering. So you should be in a position to know the meanings of the writs also. Right. So which of the statements given are correct? So option C, statement 1 and 3 are correct. Right. Next question, question number 14. Right. So question number 14, with reference to Ayushman Bharat Digital Mission, consider the following statements. So right. So with reference to Ayushman Bharat Mission, consider the following statements. So this comes in the governance part. Right. First point, private and public hospitals must adopt it. Second option, as it aims to achieve universal health coverage, every citizen of India should be part of it ultimately. Next is, it has seamless portability across the country. Yes, you can see if you study the features of Ayushman Bharat Digital Mission, all these features are there. So you will also have the seamless portability of especially the health records of the people, or health records of the people. So correct option is option D. Statements 1, 2 and 3 are correct. So one of the guesswork also you can adapt is, that for the government schemes, I'm not saying every time it will happen, but for most of the government schemes, sometimes, I mean, most of the times, option will be, all the options will be given, I mean, whatever the options are given, they will be correct only. Majority of the times, but however, you should, I mean, verify it second time, and you should be in a position to understand the options, and you have to make sure that all the statements are correct. Then only you have to go for the all the above, all the given options are correct, that option. But just I am giving a hint that most of the times, I mean, if there is a question about the government scheme, the correct option would be most of the time, majority of the times, all the above. Right. Next question. With reference to Deputy Speaker of Lok Sabha, consider the following statements. Right. So statement one is, as per the rules of procedure and the conduct of business in Lok Sabha, the election of Deputy Speaker shall be held on such date as the Speaker may fix. Right. Second, statement 2, there is a mandatory provision that the election of a candidate as Deputy Speaker of Lok Sabha shall be from either the principal opposition party or the ruling party. Third statement, the Deputy Speaker has the same power as the Speaker when presiding over the sitting of the House, and no appeal lies against his rulings. Statement 4, the well established parliamentary practice regarding the appointment of Deputy Speaker is that the motion is moved by the Speaker and duly seconded by the Prime Minister. So clearly, right. So question is, which of the statements given above are correct? Clearly, statement 1 is correct. So as per the rules of procedure and conduct of business in Lok Sabha, the election of Deputy Speaker shall be held on such a date as the Speaker may fix. So this is a correct statement. Right. So this is incorrect. There is a mandatory provision. So generally, tradition is followed that the Deputy Speaker hails from the majority opposition party or principal opposition party, but it is not mandatory. It is coming as a convention. It is coming as a tradition. Right. So this is incorrect statement. Third statement is correct. The Deputy Speaker has the same power as the Speaker when he presides the House. He is not at all subordinate to the Speaker, and no appeal lies against his ruling. So this statement is a correct statement. Statement 4 is incorrect statement. It is a well-established parliamentary practice regarding the appointment of Deputy Speaker is that the motion is moved by the Speaker and duly seconded by the Prime Minister. So this is also an incorrect statement. It is, generally the Speaker will be presiding, so he will not propose a name for the position of the Deputy Speaker. Right. So this is an incorrect statement. So statements 1 and 3 are correct. Right. So these are the questions from 2024 and 2023. Right. So in the next coming 2 sessions, we will try to complete the questions for rest of the years. Because this is the first class, I have gone little bit slower. In the next sessions, we will try to go a little bit faster, and we will try to complete the all the questions in the next 2 sessions. So you can see here you got almost 15 questions from the polity subject. So this is also a very good number, we can say very good number. Right. So thank you for joining the session. See you next time. Until then, have a